moments. But first, today is the final day of the IEBC Dispute Resolution Committee sittings. The committee is expected to issue its verdict on whether former Nairobi Governor Mike Sonko will be cleared to vie for the Mombasa gubernatorial seat. Well, the sitting is still underway. Let's cross over and listen in to what's happening at the Milimani Law Courts.
The focus is on Article 193 2G. Council highlighted the expression in accordance with any law in quotes within the provision to emphasize his argument that the two provisions speak the same language. To bring this into perspective, Council stated that Article 75 of the Constitution must be read together with Article 99.3 and 193.2G and 3 of the Constitution. With this in mind, Council submitted that the complainant brought to the attention of the respondent that he had an active appeal, but the respondent insisted that she needed to see evidence to prove that he indeed had an active appeal against his removal from office of governor, Nairobi County, through impeachment by the Senate. Council explained that they had supplied the respondent with a letter written by the complainant's advocate confirming that indeed there was an active appeal. The respondent by the complainant on 7th June 2022 included a petition of appeal and the court's directions that the matter will be mentioned on 10th June 2022 before the Deputy Registrar for further directions. He asserted that these documents were presented to the respondent via a forwarding letter from his law firm. Council further explained that the following day, 8th June 2022, the Office of the Registrar of the Supreme Court of Kenya wrote a letter confirming that indeed there was an active appeal before the Supreme Court challenging the Court of Appeal's decision on the question of complainant's impeachment by the Senate. Council argued that once presented with the document, the respondent was duty-bound under Article 47 of the Constitution to take a step and investigate whether those documents were authentic. The respondent ought to have written to the Supreme Court to clarify the issues. She submitted further that Regulation 45(3) empowers the respondent to accept documents and seek clarification. It was Council's further contention that under Article 249 of the Constitution, the respondent had the duty to ensure that she protected the sovereignty of the people, since that is what in the Constitution. Council submitted that Article 193.3 ought to be read together with Article 182 of the Constitution on eligibility and qualification of a candidate to vie for a gubernatorial seat. Council sought to bring to the fore the supervisory jurisdiction of the High Court under Article 165(2) of the Constitution, and argued that if the outcome of impeachment proceedings can be challenged at the High Court, or one can appeal to the High Court all the way to the Supreme Court if convicted, what is different with a governor who has been impeached, benefiting from Article 193.3 of the Constitution? He contended that the respondent did not properly apply her mind to these constitutional imperatives, and as such erred in disqualifying the complainant. Council argued that Article 75 or any other article of the Constitution cannot be applied in isolation. that they must be applied holistically, Counsel referred to Article 259(1) of the Constitution. He argued that the respondent ought to have done.
Live proceedings there from the Milimani Law Courts as the IEBC Dispute Resolution Committee is set to give its verdict on whether Mike Sonko will be cleared to vie for the Mombasa gubernatorial seat or not. We'll bring you the latest as and when.